Ladies and gentlemen, what precisely constitutes an Aifm? You may wonder. So, in this video I will succinctly and meaningfully elucidate this very topic for you, so you will soon find yourself being fully informed about the so-called alternative investment fund manager. So, where did they come from, these AIFMs? I mean, what justifies their existence, so to speak? Well, let us briefly examine the words of the name itself. Alternative investment fund managers. So it must involve somehow managers which do manage alternative investment funds. Well, this was quite straightforward. Well, it's not quite that simple, because somewhere these AIFMs must originate from, so to speak. I mean, they must find some justification in an event which was, or which is actually universally applicable. Otherwise, well, we would find ourselves in the Middle Ages, where one measured in ells in one dookie and in the next with the foot length, well, and so forth. Well, we do find this universality in Article 4 of the 12th July 2013 law. What exactly was that again? Absolutely correct. It is the implementation of the 2011/61/EU directive. And this very directive is also known as the AIFMD. What's that? That is the Alternative Investment Fund Manager Directive. Well, at a European level. Be that as it may, if one takes actually a glance into this very directive, as mentioned before, Article 4, then one will encounter something like each AIF in Luxembourg must have an AIFM. Yeah, that's actually somehow in that form. It is standing in Article 4. Then, well, that this AIFM then is responsible, therefore, to conduct this very law. I mean, the law, the implementation of the AIFMD. Well, so now we know where they do come from. They come from this very law, from the AIFMD, actually from the implementation in Luxembourg of this very directive. So if one then is continuing to read, one will find the distinction of the Article 4 in A and B, and in these two, the distinction is made between an external and an internal AIFM. So now the question is, of course, external from what? Or internal of what? And of course, thereby is meant the AIF, the Alternative Investment Fund. So either it has an external AIFM, an external manager, or it has an internal manager. And internally would then mean what? Well, if it has an internal management system, so to speak, an internal manager, then that actually means that the AIF becomes itself an AIFM. In the external case, usually one is speaking of the third-party service providers, which we do have a lot in Luxembourg. So now the question is, what is an AIFM in practice? I mean, until now it's just quite theoretical. To understand this, one must ask, I wanted to say, but may ask the question, what was again a Menko? Isn't that somehow similar, or is it the same to an AIFM? What is the difference? Are they AIFMs actually, these Menkos? Yeah, yes, not quite. Menkos, also known as management companies, they are not AIFMs, not necessarily. Actually, just simply therefore because AIFM is one word and Menko is another word. So it's two words, and usually jurisdictions do not just invent different words when, well, one should hope so at least, when it is not necessary. Actually, the jurisdiction invented also another word, which now is called IFM. That is the Investment Fund Manager. And what is that? Well, that is the group above these other two groups. And what does that actually mean? I mean, where is this distinct? Where is this distinction made by the jurisdiction? Well, that we're going to find out when we have a look into the CSSF statistics. But actually, by mentioning the CSSF statistics, if one is having a look at the statistics from, I think it was the third quarter of 2023, then we do see there's this distinction also made. And there's mentioned the chapter 15 of the 2010 law. So where does this come from? Therefore, it is quite useful to have a precise look. There it states somehow the following. I don't remember it word by word, but like management companies established or incorporated under the 15th article of the 2010 law shall be called Mancos or IMFs. And everything that is listed under the 16th, under Article 16, that shall be called AIFM. Now, it was quite useful to know what is standing in Article 15 and Article 16 of the 2010 law. And what is the 2010 law, ladies and gentlemen? Yeah, it's the directive, the implementation on a national level of the directive 2009/65/EC. Well, and this is broadly known as UCITS 4. Yeah, so if one has a look then into UCITS 4, into this directive, actually not into the UCITS 4 directive, but into the national implementation, so the law of the 17th December 2010, and then one realizes chapter 16, which is one of these distinction paragraphs, is related to everything from Article 125, 1 and 2, which is quite a lot, and a lot of text. And it is referred there as other management companies. So, well, and what is standing in chapter 15? A lot is standing in chapter 15. It consists of, I think it was like 12,000 words. That's quite a lot. Luckily, we don't have to read all these 12,000 words, no. We can just know that thereby, because I think it's like the second headline after the mentioning of the chapter, and that is saying like management companies that are managing UCITS. And there we have it. We are dealing here with everything that is able to manage UCITS, which one can also call investment fund manager. Yeah, IFM. Yeah, that's actually, so to say, then the superordinate group. And what are UCITS? Well, we've had that a moment ago. That's the 2009/65/EC directive that are UCITS. You can look it up, or you can just watch one of the other videos where it is explained. So Mancos are allowed to manage UCITS, and AIFMs are not allowed to manage UCITS, but everything else. Meaning these two entities actually behave like the logical meaning any odd number is a number. Now build the opposite of that. Any number is an odd number. So you can say water is blue, blue is water. Not correct, ladies and gentlemen. So it is more correct to say if B, then not necessarily A. Under that logical pattern we are operating here. Thus, we have clarified that already. So now we do understand the difference between a Manco and an AIFM. And we do also have a rough oversight, or idea, better to speak, what they actually do. Namely, managing AIFs. That's what they do. Now, of course, the question arises, okay, what does that mean? What exactly are the tasks involved in managing an AIF? If you find yourself, in your professional life at least, as a fund admin, for example, or as a fund structurer, being part of a fund structuring team, or working just somewhere at a third-party service provider, and we do have a lot of them in Luxembourg, like, for example, IQ, EQ, Adstack, State Street, Apex, and even major banks are acting as service providers. I think JP Morgan, for example. Well, aren't you somehow then also involved in managing the fund? Aren't you? I mean, you are doing many things. I mean, you are paying the VAT, for example, in case you are an admin. So after all, nothing happens without you, right? Isn't it? You are absolutely correct. But, however, ultimately, you have nothing to say. Excuse me. I mean, of course you do have something to say, but not in the regards of the management of a very fund. You're mostly just the executive of the whole affair. You serve akin to governmental structures of a democratic society, for example. You do serve as the police, so to speak, because you are the executive. And the police has nothing to say about the law. Well, of course, if you are corrupt in your position as a fund admin, then you would actually present more of a paramilitary militia. But I assume that no paramilitary militia is watching my channel. As the executive, you don't determine much, and that is also good that way. Because if that was the case, ladies and gentlemen, it would be akin to calling the police, or actually when you call the police because a deranged elderly lady is shooting 9mm bullets through your apartment windows, the police officer then, who takes the call actually, would then decide if this situation or this event actually was generally significant enough to be enforced by the executive. Well, imagine if the police officer were your neighbor and good friends with your elderly neighbor who's currently, well, experiencing a cocktail of Alzheimer's, psychosis, and, well, a pronounced risk affinity shooting up your windows. Not a good situation. And that's also the reason why, as a fund admin, it is quite okay in case you do not have much to say about the investment decisions. Typically, for example, fund admins are thereby not AIFMs, although clients simply assume they are at times, for they just wish that that may be the case, or because they just want them to be the AIFMs. However, in the case of, for example, IQEQ, because it comes to my mind as an example, companies can be both. They can be IFMs and traditional third service providers, or service providers generally. I can surely display this right away. Such information you are always going to find at the RCS. The RCS is standing for French conglomerate of words, Registre des Commerces et des Sociétés, I believe. Well, of course, I cannot pronounce French, so yeah. Well, and this is actually something like a company register. And I hope I won't forget to display, for example, right now, the RCS entries for IQEQ. Thereby you can always see which companies are behind a company, because usually it's never just one company, but it is consisting of various companies and holding companies and so on and so forth. And in IQEQ's case, you should find something like fund management company, and what do I know, maybe IQEQ fund services or something like that. So now we still are dealing with the unanswered question. What do fund managers actually do? More specifically, ladies and gentlemen, what does it mean to manage an AIF? And because, I mean, we know now fund managers can be also Mencos, and Mencos can be AIFs. Well, not the other way around. So the attentive listener, or rather the attentive viewer, already knows, because I think I've said something a few minutes ago, like, are responsible ensuring the conduction of this very directive. And what was meant thereby again? Well, that was meant respectively 2011/61/EU still. And that is the AFMD. That means there we do not find only in the national version, in Article 4 of the law of the 12th July 2013, where the existence of the AIFM is justified. This, actually, the attentive listener will also have not overlooked that, well, this is actually just the case. By this law simply justifies the existence of AIFMs through this very Article 4 as given and justified from within itself. But nonetheless, one must also find there somehow the activities an AIFM must be engaging with, must be involved in. What are the duties? That's what I mean. So, and we do know also that the AIFMs must ensure, namely the compliance of the law of the 12th July 2013. We even know that the true AIFs are only those which are incorporated under Article 125.1 and 125.2. Yes, which is actually Chapter 16. I mean, the beginning of Chapter 16. And actually it is Chapter 16, these two. But also that Mencos also be AIFMs, you know, as they usually are simply allowed to manage more than AIF. And I mean, like the singular AIFM said to be, so to speak. So a look at the table of contents might not hurt regards finding out more. So it is apparent that an AIFM is tasked with ensuring compliance with the AIFMD with respect to portfolio management and risk management services to one or more AIFs as its regular business, irrespective of where the AIFs are located or what legal form the AIF takes. Well, the AIFM can actually also outsource various of these sections, but later more. Why an AIFM should take this role very seriously can be found in Article 15, if I remember it correctly. Actually, in cases I don't remember something correctly, I will notify you by a message on the screen later on. I think Article 15 roughly states that the AIFM is responsible and held accountable for any losses which, well, are made, or better to speak, resulting from a failure to fulfill their supervisory duties. And here it becomes interesting, for I believe in Article 3 is stated, of the AIFMD, of the implementation of the AIFMD in paragraph 2, so of the law of the 12th July 2013. I think it was divided into two paragraphs, A and B, and A is applicable to AIFs falling under the Article 89.2, as I think, because 89.2, as I remember, is then referring to 88.2, paragraph A, I think, Roman A, excuse me, and that means AIFs which have appointed an external AIFM. Excuse me, actually, the latter paragraphs, they are coming from the UCITS 4. AIFMD is referring to UCITS 4, so therefore I have to tell you the ones from the UCITS 4. Practically, this means, as you may know, the RAIF must appoint an external AIFM, which is not the case, for example, for SIFs or various other vehicles. Well, in paragraph A of this mentioned Article 3, there is stated the threshold of 100 million euros, and in paragraph B is the 500 million euros threshold stated. And that is kind of a lot of money, at least for me. Actually, Roman B was only applicable to funds which are unleveraged, which do not have any redemption rights exercisable for 5 years after the initial investment that was made into the AIF. What does that actually speaks for? Where does it hint? What does it, is this a hint? Yes. Actually, we are talking here usually then in these cases about closed-ended UCIs, for the structure appears very close-ended. So this is, for example, respective PE or RE funds, well, which are usually closed-ended then. By the way, this very Article 3 and 4 actually of the AIFMD implementation law is the distinctive point of something else one will automatically come in touch with or come across when dealing with AIFMs, and that is the question: do we have here an authorized or a registered AIFM? Yeah, well, also in these both articles is stated what the minimum requirements are for being a registered AIFM, and well, these are not that many. It is 3 points, and it means a register with the Commission de Surveillance, however one that's called, the CSSF, and identify the AIFs that they manage to the CSSF, comply with minimum reporting obligations, and well, that means actually to provide the CSSF with regular information on the main trading instruments, the principal exposures and concentration of the AIFs. And the third point, if they no longer satisfy the first two conditions set out above, inform the CSSF and apply the authorization within 30 calendar days. Yeah. And now it becomes a little bit more sophisticated. The requirements for the authorization of an AIFM include, well, it is quite a bit. So I won't go into any of them. I will just put them somewhere at the screen, for it was simply a little bit too much to read it all. Then this video would take, I don't know, longer than it takes already. So in case you have a serious interest, an earnest interest to have a look at that, just pause the video right now and just have a look and yeah, do that. Otherwise, the AIFM is responsible, for example, ensuring that a depository is in place or is present. Incidentally, an AIFM must be always separate from a management company. I believe this is stated in Article 20. But also, for example, that the NAVs, also the net asset values, are calculated and transmitted. And usually something like this will then be outsourced or find itself being outsourced to other service providers. Well, or it can be also an in-house service provider that then takes on these tasks, as is possible with IQEQ. But of course, this must be again oriented by the client. I think that is stated in Article 14 too. More exciting, however, is Article 13, which states that the management company should establish management obligations, I wanted to say, but I mean regulations. So, which are then lodged with the trade company register. Here, however, in Article 13, we are dealing with MANCOs. Well, because actually right now we are looking into UCITS 4, as it only concerns FCPs in this case, or at least common funds. Well, find that actually also in Article 13. It was simply too much to present it in this short presentation here. So when it comes to UCITS, you can find the exact investment policies from Article 40 onwards in the UCITS 4, or just call it Chapter 5. Yeah, or simply look it up in the UCITS directive itself. Cross-border regulations are, of course, also covered from all angles here in all areas. So, ladies and gentlemen, it is now quite evident what the purpose and scope of AIFMs actually is or are. It is a compliance position. Yes, AIFMs are mainly a compliance position. They are responsible for ensuring that all regulations, which one of course also knows as a fund admin in many cases or somehow working with AIFs, well, that they are at least complied with. That's the main objective. While they act, of course, on behalf of the fund, meaning the fund owners, the respective investment decisions. But depending on, it can be that the AIFMs, or the fund managers, they're actually not deciding much, for many funds are that narrowly constructed or designed by the fund owners, however the ownership may be structured in the end, that the AIFM in the end literally only secures that, well, there is compliance with the actual regulations of the investments that the fund wants to do. Yes, this is possible due to Article 5 for Roman B, I think. Well, there it is stated that the AIFM is allowed to offer other services, something like that. It's two things, it's other services and investment consulting or something like that. Don't nail me on the words, but something like that. Well, and if things then are outsourced, such as administration, for example, then as a fund admin, you naturally contribute to ensuring that everything regarding the administration is correct, of course. For this, you usually do find in one of these folders that you have there in your fund, hopefully you have there something that is called like Fund Administration Agreement. If you want to have a closer look into how these things are structured, you can just do so by having a look at these very documents. And you know what exactly is your duty. And you will see that the AIFM is usually included in these agreements. Ladies and gentlemen, you should know now what an AIFM is. You should understand why they are, what they originate from, and what they have to do. So, well, it may be also worth mentioning that the AIFMs themselves, however, the provisions of the 1915 law, I don't remember the dates, August, I think 10th of August, is applicable actually. That is the law of on commercial companies, as they are, of course, incorporated as such. So, as an SA or SAR and so on. So, you have made it. If the video was useful to you, helpful to you, has provided you with some mental clarity, respective AIFs, feel free to like it. AIFMs. Some when I might upload a video which goes into the details of the AIFMD. Well, in case, you will find the link in the video description. If you want to stay up to date, respective everything around the AIF industry, especially in Luxembourg, of course, feel free to subscribe to the channel. And otherwise, just have a good time and see you in the next video. Thanks.